Mr. Moorstein.
May it please the Court, good morning. My name is Barton Moorstein. I represent the appellee Carl Clark in this case. The Court of Special Appeals decision was correct on three different levels. It correctly interpreted 3507.1 of the Labor and Employment article. It correctly supports and encourages the fee-shifting policy set forth by our legislature to award attorneys' fees in a case such as this. And it correctly interprets and construes the decisions of the Court of Appeals and the Court of Special Appeals in the cases that deal with the awarding of attorneys' fees.
Mr. Moorstein, isn't it a precise issue here where the jury is asked to determine as a fact whether there was whether there was a bona fide dispute, and the jury answers that question and says yes, whether a judge is then bound by that factual determination, and that's the end of the attorney fee issue. Isn't that's the issue?
That is the issue, Your Honor.
Now, there was this court a number of years ago when the court merged law and equity together. A case came up that seemed to me to have an analogous touch to it. When there was a law action tried before a jury and an equity action tried before a judge that had the same factual issue in it. And what do you do in that situation? The court said you let the jury determine it, and the judge is bound by that. Now, why should that not be the rule in this instance?
There are a couple of reasons why that should not be the rule. First, Your Honor, as you indicated in your opinion in Admiral Mortgage, the issue of enhanced damages is entirely different from the issue of the awarding of attorney's fees. And I quote your language, attorney's fees are a different matter. And you specifically said the determination of attorney's fees is for the judge.
The amount as to what is reasonable, not whether you're entitled to them, but what the amount is going to be.
Your Honor, I would suggest to you that in your follow-up opinion in Friolo 1, you made yourself more clear, if I may. What you did,
I'm happy to know that.
You expanded what you meant when you used the language, not just the determination, but you used the language, the allowance and the calculation of attorney's fees is for the judge.
In Friolo, the jury did not make a determination of bona fideness, did it?
Well, Your Honor, what they did, as you may recall in Friolo 1, it was a 10-count complaint. 2 or 3 of the counts went to the jury. 2 of those counts dealt with the issue of enhanced damages. And the jury made a finding that there was not going to be an award of enhanced damages. Nonetheless, attorney's fees were asked for and awarded. Right. And what you, again, I can only go from the words that you use and the words that you choose not to use. You use the words, the allowance and the calculation. The common meaning of the word allowance is whether to allow in the first instance. And the calculation, which is the second word that you used, is what is the amount of the damages to be awarded. That was then interpreted by Judge Bell in his decision in Friolo 3, where he used similar language. He used the allowance and determination. And what Judge Bell parsed from the words that you used and chose not to use was that the issue of the absence of the finding of a triggering event is a factor to be used in the lodestar calculation for the awarding of attorney's fees. It didn't say that they were prohibited. What Judge Bell said in footnote number 12 of Friolo 3 was that the issue of attorney's fees is questionable. He said he didn't use the word doubtful. He didn't say that it was not going to be awarded. He said it was questionable.
But the jury in that case did not make a finding of bona fideness, did it, with respect to attorney's fees?
What the jury did not, I have not seen the jury verdict form. I assume that the request was made for enhanced damages, and the jury elected not to award enhanced damages. So I am assuming that when you made your decision in Friolo 3 and Friolo 1, that you knew all those.
Well, right. The jury, the enhanced damages was clearly for the jury to determine.
Correct.
That was damages.
Correct.
In the case. What Friola, at least 1 or 2, held was that the setting of attorney's fees is not for the jury, it's for the judge to determine. I don't recall, and maybe you can correct me if I haven't looked at the briefs in that case recently, whether there was ever an issue raised about, in the absence of a jury finding, whether attorney's fees could be awarded. I thought the whole case was about who was going to do it and how they were going to do
Your
it.
Honor, my recollection of Friolo 1 procedurally was that there was no finding of enhanced damages, notwithstanding that the prevailing party, the plaintiff in that case, filed a request for an award of attorney's fees, and it was awarded, and no counter-appeal was filed to the finding of attorney's fees. And therefore,
But you could award, you could have a finding, if there was no bona fide dispute, do you agree you could have an award of counsel fees even if there is no enhanced damages?
yes,
They don't have to go together.
that is correct.
The triggering mechanism is the same.
That is correct. That is correct. And because, based on your analysis and your decision in Admiral Mortgage, where you distinguish between enhanced damages are here, awarding of attorney's fees is here, they're two distinct issues. And while you use the word, you only use the word determination of attorney's fees in Admiral Mortgage, in Friolo 1 you used the words the allowance and calculation. They're different. They have different meaning. And I assume that what you said, you meant. And you meant the allowance means whether to allow in the first instance.
Even though that wasn't an issue in the case?
Even though it wasn't an issue in the case.
Maybe you're assuming too much.
Well, Your Honor, the interpretation of both those words and the awarding of attorney's fees is consistent with the legislative policy. This statute was enacted for a very specific purpose, which you explained at length in your opinion. And that was, as you may recall, is that there was a shortfall in the number of employees through the Maryland Employment Commission who could enforce failures of employers to pay wages. And therefore, the legislature enacted this provision to basically provide a private cause of action and to encourage people.
But if the jury makes a specific finding that there was a bona fide dispute, why should the judge not be bound by that fact finding?
Because they are two separate and distinct.
Supposing it were the other way around, the jury found that there was, could the judge then say there wasn't?
From a strictly interpretive manner of looking at that, yes, a judge could say that. I do believe, however, that given the legislative policy that strongly encourages fee-shifting provisions, especially in this type of case, that it would be hard-pressed for a judge to say, okay, the jury has found that there has not been a bona fide dispute, but I'm not going to award damages. I think clearly that decision would be subject to review.
I don't know. I mean, the judge's credibility assessment of the people who are testifying on the issue may be dramatically different from that of the jury.
It could be, but I believe that to be consistent, even if a jury found that there was not a bona fide dispute, I believe that a judge could find that for whatever reason it would be inappropriate to award attorney's fees. I think it would be inconsistent with the legislative policy, but that interpretation is entirely consistent with Admiral Mortgage, Friolo 1 and Friolo 3. I believe that the decision, in order to be entirely consistent and to be clear, this Court must conclude that the triggering issue for enhanced damages is a jury issue, and the
triggering issue for the awarding of attorney's fees is an issue for the judge to decide.
Well, then why would the issue go to the jury?
The issue of attorney's fees, it wouldn't. The issue would go to the jury for the purpose of enhanced damages.